Yes, please.
I'd like to begin by expressing my deepest gratitude for this extremely valuable opportunity. Sir, with your permission, I will quickly make 3 points by way of rebuttal, and then I will focus on the methodology for determining whether there has been a violation of basic structure, which I derived from Justice Kapadia's, Chief Justice Kapadia's judgment in Nagaraj, where he provides a very wonderful framework for that. And so I'd spend little time on that because I think we need to move towards the methodology for deciding how to, what the issue would be. And lastly, sir, I come to very quickly to possible way forwards in terms of where we can move. So with your permission, sir, I'll begin by making 3 short submissions by way of rebuttal. I think a couple of things that have been the theme of the presentation on the side of the union and other respondents has been to characterize the social and educationally backward classes as castes and to say that reservation of SEBC is casteist reservation. So I want to start, sir, by reading to you very quickly the criteria which are now on the website of the National Commission for Backward Classes for including a community as a backward class. It says, sir, castes and communities. There, first of all, sir, these criteria are divided into 3, as you may know: social, educational, and economic. They have to full any community, any caste or any community, generally considered as socially backward. That's number 1. Number 2, castes and communities which mainly depend on agriculture and or other manual labor for their livelihood and are lacking any significant resource base. Castes and communities which for their livelihood mainly depend on agricultural and or other manual labor for wage and are lacking any significant base. Castes and communities, the women of which, as a general practice, are for their family's livelihood engaged in agricultural and or other manual labor for wage. Castes and communities, the children of which, as a general practice, are for families' livelihood of a supplementing families' low income, mainly engaged in agriculture and or manual labor. Castes and communities which in terms of the caste system, not as castes, in terms of the caste system, are identified with traditional crafts or traditional or hereditary occupations considered to be lowly or undignified. So this is a stigma, sir. Castes and communities which in terms of the caste system are identified with traditional or hereditary occupations considered to be unclean or stigmatized. Nomadic and semi-nomadic castes and communities, denotified or Vimukta Jati castes and communities. Caste and this is social, sir. Then this I consider political, although there is no subheading. Caste and communities having no representation or poor representation in the state legislative assembly and or district level Panchayati Raj institutions during the 10 years preceding the date of the application. The term poor representation may be taken to refer to a caste or community whose presence in the body is less than 25% of its proportion in the population. Educational. Castes and communities whose literacy rate is at least 8% less than the state or district average. Castes and communities of which the proportion of matriculates is at least 20% less than the state, and of which the proportion of graduates is at least 20% less than the state. Economic criteria, sir. To be a socially and educationally backward class, you have to fulfill the following economic criteria. Castes and communities, a significant proportion of whose members reside only in kacha houses. Castes and communities, the share of whose members in number of cases and in extent of agricultural land surrendered under the Agricultural Land Ceiling Act of the state is nil or significantly low. Castes and communities, the share of whose members in state government posts and services of Group A and B, classes 1 and 2, is not equal to the population equivalent proportion of the caste or community. So any caste or any community, any group of people that fulfills these criteria are entitled to be a socially and educationally backward class, which is why, sir, this honorable court very rightly recommended that transgenders be included as an OBC community. Transgenders. The National Commission of Backward Classes has recommended that orphans be included in the list of OBCs. So this category, created by the founding fathers of our Constitution, has yielded the desired result. It has become the main category uniting the common people of this country across religion and across caste, across region, across geography, as backward classes fighting for greater representation and a greater share of voice in this country. And as I mentioned last time, sir, every Varna is represented, every religion is represented, every Muslim in Kerala belongs to the backward classes because they really suffer from deprivation. So the first point I want to make very simply, sir, is to rebut this idea that this reservation for communities that fulfill these criteria is being repeatedly vilified as casteist reservation. What is the basis, sir? A caste is entitled to be a class, but casteist mindsets see a class only as a caste because they cannot see anything else, sir, other than a caste when they look. So therefore, I think we must recognize the value of creating a uniting category that cuts across various kinds of deprivation, and we must strengthen it. Now, is that being abused? Yes. What is not abused? And that's why the National Commission for Backward Classes rejected that JAT should be made backward classes. And the government, for political reasons, then government went ahead and gave them OBC category. So these mechanisms are working, sir. And I'm the first to say that these criteria must be strictly applied for the objective of giving voice and representation to people who are living in this condition. And they must be reviewed, monitored, and people who are not in these conditions, which frankly bring tears to my eyes, sir, when I read these conditions. We are talking of actual people, that they should have voice and a share. Otherwise, what is the purpose of our having freedom and democracy, sir? But it should be monitored, and it is not. But we should not throw the baby out with the bathwater, sir. That is my first point. Second, very briefly, sir, is this relationship between weakness and backwardness. I want to rebut the idea, sir, that weakness and backwardness are totally opposed to each other. When I saw the three-circle formula that Honorable Justice Butt put forward, what appealed to me was that there was a continuum running across that circle, and that was weakness. Weakness. The word weakness comes from the Proto-German word Weiku, W-A-I-K-U. It means soft. It will yield. No capacity to resist. So if you take Justice Butt's circle, as he said, at the center you have the greatest weakness of SC and ST. Then you radiate out and the weakness is less. The capacity to resist improves. And at the outer end, I would say are residual categories. Then what he said, what Justice Butt said, reflects also very much, according to me, what Dr. Ambedkar also taught, that there are residual categories that may not be captured effectively within these categories of weaknesses. They're not homogeneous. Their types of weaknesses are hugely varied. They practice very unhealthy habits even towards each other. There's massive human suffering in these groups, and to call them homogeneous because they're assumed to be caste does not do justice to that category, sir. So I think we must understand that weakness is a quality. It's a quality of yielding, being soft. Backwardness is a rank. Are you towards the back or are you towards the front? Weakness produces that rank, but you can't, they're not intended to be opposed to each other. You cannot use backwardness to fight weakness or weakness to fight backwardness because they're two categories. And I saw in these three circles, sir, a rank and a recognition of weakness as I saw it myself. And I thought that was quite very helpful. Lastly, sir, my rebuttal point is, please don't divide the joint family, constitutional joint family of social, economic, and political. Sir. They go together. The rest of the world has just begun to realize that what is social is economic, what is economic is political, what is political is social and economic. They're all different sides of a complex human condition. And so we have moved away, sir, from, in the last 70 years, from measuring poverty simply by looking at consumption and the right to buy food, to multidimensional poverty indicators, where we are looking at various aspects. And we find, sir, that poverty is defined as a multidimensional problem. No less than the IMF said, sir, that it's a multidimensional problem that goes beyond economics to include, among other things, social, political, and cultural issues. This is a recognition that we had in 1950s in our constitution, always speaking of justice, social, economic, and political. And to achieve justice, social, and political, economic, you cannot just look at economic criteria. So separate from Indira Sawhney, sir. Indira Sawhney expressed the right sentiment. Now, if today you were to offer me the proposition that reservation should be on social criteria alone, I would be the first to oppose it, sir. I will say, don't ignore the economic criteria. Don't ignore the political criteria. If you say reservation should be only on political criteria, I will be the first to oppose it. I'm not against economic criteria, but I'm against single point criteria to determine human suffering and human backwardness. Poverty remains an extremely complex morbidity to recognize. But if we have made any progress, it is to realize the complexity, not to reduce it to 8 acres of land or X amount in the bank. So we've left that behind, and I think India will be shamed in the rest of the world if we still show that that is our approach to understanding human suffering, sir. So these are my 3 rebuttals, sir, very quickly. I'm aware of the time. Now I want to move to 3 basic structure violations, sir. We've all focused, and my learned colleagues who are far more able than me and far more knowledgeable than me have very deeply pointed out many, many basic structures, although the respondent side has tried to narrow us to only two issues of whether or not the economic criteria can be is valid under the Constitution, whether there's 50% reservation. But actually, number of submissions have been made on basic structure. But many of these submissions have focused on the exclusion. I want to focus on the inclusion, sir. My real problem is with the inclusion, not with the exclusion. And what is my problem with the inclusion, sir? My problem with the inclusion is that for the first time in our history, being a member of a forward class, socially and educationally forward class, has been made a prerequisite for getting government assistance. If I'm a member of a socially and born as a member of a socially educationally backward class, sir, how do I become a member of a socially and educationally forward class? Never before, sir, in the history of this country, has there been a requirement that to get government assistance, you have to be a member of a socially and educationally forward class. You have to be socially and educationally forward. This is why I think until recently, the idea was to tackle financial weaknesses. Yes, there are genuine cases of financial weaknesses. I myself know one person, sir, who's a member of the royal family of a state, and he was telling me how he grew up in utter poverty, had to eat roots when he was a child. And I told him, I said, yes, you had to do that, and you should never have had to do that. Your suffering is no less or no different than any other child in this country. But you must remember that no door was closed to you by society. No door was closed to you. I know someone else who was very poor from a priestly family because the father and the grandfather decided that they want to serve the temple and be priests and live in that condition. But when the children decided, no, we will study, sir, every door opened for them, sir. Every door opened for them. In school, in college, outside the country, in the best jobs in the country, and their friends, my friends, both of them ended up in top positions in the country. So our problem is with doors being closed by society on us. And that is a problem that can be solved only by forcing those doors to open through a reservation, a set aside such as reservation. Now let me turn to, so my first problem is that this requirement violates the basic structure. And I will come to that in the methodology in more detail, but that's the first. I'm only submitting that 3 things violate the basic structure. One is this prerequisite that you must belong to a forward class to get EWS. is a violation of the basic structure, number one. Number two, sir, there is a requirement that, sorry, sir, I'll just take 1 second. Yes, sir. The second difficulty with the violation of the basic structure is that is about the way 103 amendment treats reservations. Now, I believe reservation is a very dangerous instrument, sir. It's a very dangerous instrument. Because it necessarily involves displacement and discrimination. You're pushing someone out to get a chair, which is why we are before you, sir, because the question is that being done fairly and justly or not? Now, because reservation is a very dangerous instrument, Dr. Ambedkar himself in the Constituent Assembly said, don't apply it to more than 50%. Not because he wanted that to be a rigid criterion to be used to destroy the social and educationally backward classes and the SC, ST, as some of my colleagues may wish to do. But because he realized the danger of reservations, and he wanted more than anything else that every Indian should have equal opportunity. That's what the struggle of the movement always was. So it's a dangerous instrument. So therefore, they anchored those reservation, put chains on it, so that it will not run out of control. The chain was that you shall be used only for representation. And you shall be used only for representation by backward, for those who are being discriminated against. That instrument, you can do anything else. You can help people in any other way. But this dangerous fellow, don't use him for anything else except to open the doors that society closed on you. You use him as a lever to open those doors and nothing else. Now, what 103 does is, sir, it destroys those harnesses on reservation. It says to uplift someone. Right? It doesn't matter whether he has suffered from discrimination or not, but to uplift someone, you can use reservation. It is reservation unbound. If this amendment is approved, in short order, sir, there will be thousands and thousands of programs in this country to give exclusive assistance to various groups of people through reservation. Reservation will be unbound and let loose on this country. So instead of tightening that and making sure that it does not apply except where the truly deserving need representation, we are doing the opposite by universalizing and compartmentalizing reservation. I agree, sir, with you that compartmentalization already exists. It's a problem, sir. Let's not make it worse. When I heard the arguments about compartmentalization, ma'am, my mind went back to 1896. I was never there, but went back to the Supreme Court of the United States in 1896, where they considered a case where a law was enacted by the state of Louisiana that railway compartments, it's ironical that the other side used the word compartment, railway compartments will be reserved by race. One compartment for whites, one compartment for blacks. And if you a black entered a white compartment, you would be fined and prosecuted. And so some civil rights activists decided to test that law. A man who was partly white, partly black entered the compartment. He was caught, he was prosecuted. He appealed the case. The case went to the United States Supreme Court in a case called Plessy versus Ferguson, 1896. And in that case, the state argued that what I am giving is compartments, separate but equal. Separate but equal was the defense of the state. Everyone, no, I'm not taking your share. You won't take my share. What is your complaint? You're getting your own compartment of the same quality. So the state argued separate but equal. And it was upheld by the US Supreme Court in what has today become one of two most disgraced judgments of that great court. It took until 1954, 60 years and 3 or 4 generations before it was reversed in Board versus Brown of Education. So I was reminded of the arguments that were made in Plessy and Ferguson when we heard an argument from our union that we want separate compartments and no one should complain, just be in separate compartments. So this is a violation of the basic structure idea of unity and integrity and harmony and fraternity of this nation. Fundamental violations. If an imprimatur of the Constitution of the Supreme Court is put on this argument, which has now been openly placed before you, sir, you cannot but take judicial notice of this. The Attorney General of the country has placed before the Supreme Court of the country, we want separate but equal. And it took 60 years for the United States to realize that separate but equal is nothing but separate and unequal. That's what it is in reality. And therefore, sir, compartmentalization and unleashing of reservation becomes a free agent virus running through society, compartmentalizing everyone. What is the legacy that you will leave us, sir? So these are my limited points, sir. I have about 7 minutes left on the basic structure violations. I move to the last part, sir, methodology. And on methodology, sir, I turn to Justice Kapadia's judgment, sir. Wonderful judgment, as all of you know him, a judge of great clarity and great wisdom. So if you turn to para 22 of the judgment in M. Nagaraj, I don't have the right, I rely on Indian Qanun and all that, sir. So I don't have the right numbers, but it's para 22.
122.
Sorry? It's page 242. Yes. Yes. I'll just read the quotation, sir. The question, because my time is limited, I have only 5 more minutes, sir. The question which arises before us is regarding the nature of the standards of judicial review required to be applied in judging the validity of the constitutional amendments in the context of the doctrine of basic structure. So this is exactly on point, sir. Justice Kapadia is giving us a methodology on how to decide the validity of the constitutional amendment in the context of the doctrine of basic structure. Sir, if I would like to go through, but I may need another 4 or 5 minutes, sir, if you permit me, sir. So, sir, para 23 says the recognition of a basic structure. It's a brilliant analysis, sir. Recognition of a basic structure in the context of amendment provides an insight that there are, beyond the words of particular provisions, systematic principles underlying and connecting the provisions of the Constitution. So what is clashing with the basic structure, sir, are the principles underlying the provisions, not the provisions themselves, is what Justice Kapadia is telling us. These principles give coherence to the Constitution and make it an organic whole. These principles are part of constitutional law, even if they are not expressly stated in form of rules. Now, this is a very important and significant limitation to the idea of basic structure, sir. Justice Kapadia is saying that if you want a principle underlying a provision to be part of the basic structure, it has already got to be a part of constitutional law, recognized by courts and binding on the legislature. So that prevents anyone from coming in and putting any random principle as a part of the basic structure by just putting it into the Constitution. So you have to go through a process where there is a law, there are principles that are established by courts, accepted and are binding on the legislature. Then you say, okay, that is the principle by which I will determine the nature of the provisions. He says the provision acquires its characteristic as a feature from this underlying principle, sir. So it's like saying there's a car. A feature in the car is it has steering wheels and brakes, and it has a radio. These are all features of the car. But some features are essential, like steering wheel and brake, but the radio is not essential. So Justice Kapadia says, I won't read the whole thing, sir. Justice Kapadia says, you look at the provision, you identify the underlying principle, and then from that underlying principle, the provision gets its features. And then you see where that underlying principle fits in the larger scheme of the Constitution, its goal and its scheme, its objects and its scheme. And then see whether it is a radio or a steering in relation to that whole scheme. If it is essential, then you say it is part of the basic structure. That underlying principle is part of the basic structure. And as I said, sir, that gives us the safeguard, a great safeguard, that unless a principle first becomes part of constitutional law, it cannot even be a non-essential feature of the Constitution. It cannot even be a non-essential feature of the Constitution. In my academic work, sir, I have emphasized this, and I've regretted that this has not been developed more to prevent, this is a safeguard to prevent random principles coming in. Now, sir, I will not read for lack of time, I will not read the rest of the passages, but I'm looking at para 22, para 23, para 25, para 28, and para 37. In 28, Justice Kapadia refers to the working test evolved by Chandrachud J in the election case, in which the learned judge has rightly enunciated with respect that for determining whether a particular feature of the Constitution is a part of its basic structure, one has perforce to examine in each individual case the place of the particular feature in the scheme of the Constitution, its object and purpose, and the consequences of its denial on the integrity of the Constitution as a fundamental instrument of the country's governance. But I think Justice Kapadia's unique contribution is to qualify that the principle must be a part of constitutional law already and must be binding on the legislature. Sir, now finally, sir, in the last part, let us apply, sir, to apply this principle very quickly, so there's no time, 15.6 or 16.6. What is the underlying principle of 15.6 and 16.6, sir? The underlying principle is that those who are poor and are socially and educationally forward and therefore deprived of reservation must get reservation. This is the underlying principle. Now, this underlying principle is not an established principle in constitutional law. It is not binding on the legislature. And it is in violent conflict with principles of equality, with the features of the Constitution that already exist to advance its objectives, which have been recognized. I have a list of, I don't have time, but I can go through the cases and the specific basic structure principles they establish. Many of them are in Keshwan Bharati. All of you know that more than I do, so I don't wish to take time on that. If you wish, I can. So therefore, sir, if you apply this principle to this test, you easily come to the conclusion that these three provisions, compartmentalism, the forwardness as a precondition, the quality of forwardness as a precondition to get government assistance. So this can be extended as a general principle to all aspects of life, sir, not just restricted to reservation. And the letting loose reservation in this society without any restriction as a benign welfare activity, like a loan mela, right? Just go and give it. These three specific parts of 15.6 and 16.6, I think, very violently oppose or conflict with the basic structure. Last part, sir. Last part. What's the way forward, sir? What's the way forward? Looking at it from the point of view of the court, I think there are two ways forward, sir. Three ways forward. One is to strike it down. The other is to sustain it as it is. But I think there's a third way forward, sir, which does not involve reading down, does not involve severance, and can solve these by basic structure conflicts in one stroke, sir. What is that, sir? And that is to take now. So this amendment is before you in two versions, sir. Now, after these 2 weeks of discussion, it's there in two versions. One version I will call the constitutionalist version, sir. The constitutionalist version. The other version I'll call the forward class version, sir. So the forward class version. Now I'll take two parts of 15.6, 16.6 and see how it is interpreted in these two versions, sir. You take the phrase economically weaker section. In the forward class version, it is interpreted as socially and educationally forward classes with a creamy layer exclusion, and other than 15.4, 16.4 classes. But in the constitutionalist version, sir, you can read economically weaker sections because of its reference to economic weakness, not financial weakness, and to poverty. The entire justification of the union has been premised on poverty alleviation, sir. And poverty alleviation, as I said earlier, is a much broader context than financial incapacity. You can read it as below poverty line, BPL, with priority to the neediest, irrespective of caste and creed, sir. Send a strong signal to this country, sir, that we've reached a stage where we recognize poverty without respect to caste and creed. This is an opportunity to do that. So the constitutionalist interpretation of this phrase would be BPL with priority to the neediest, irrespective of caste and creed. Now, the more difficult one, the second phrase, other than the classes mentioned in clauses 4 and 5. There, the forward class interpretation is this is like a yellow star that the Nazis gave to Jews. You stick it on you, and wherever you go, you're a Jew. So if you it's a yellow star is a social identity, sir. I would argue the status of OBC and SC/ST are only relevant when you are getting that, you're claiming or getting that reservation. If you're not in the room for SC for claiming benefits, you're a human being, sir. Not a yellow star. You're a human being. If I'm an OBC in one state, there is a particular community, I don't wish to name it, it's scheduled caste in Karnataka, it is OBC in Maharashtra. Now, does that person change, sir, morph from OBC into SC/ST when he crosses the border? No, he's just a human being. But his entitlements and claims may change. So this socially and educationally forward class interpretation are converting class into caste and attaching OBC, SC/ST to all of us like a caste that stays with you. They cannot see us as human beings anymore except as OBC. So we reject that approach, sir, and take a constitutionalist approach. What is that constitutional approach, sir? It is, we see this other than the classes mentioned in clause 4 and 5 as meaning that the eligibility criteria for forming the sections in Articles 15.6 and 16.6 shall be other than the eligibility criteria for forming the classes in Articles 15.4, 15.5 and 16.4. For example, in 16.4, 16.5, you have to be backward. So you cannot use that eligibility criteria in 15.6, 16.6. You can use poverty. You can use poverty. So other than, sorry. Sir, the Constitution is always at the level of criteria, sir, not at the level of identifying human beings. All these are criteria, whether it's EWS or OBC, SC/ST. The Constitution sets out criteria, broad criteria. So why are we reading the Constitution as referring to people and putting a yellow star on them? And why don't we refer to this as criteria? Now the question is, sir, last question is, this will not, as the bench observed.
So what are you saying?
Yes.
That other than means descriptive.
Other than refers to the criteria, not to the people. The criteria shall be other than.
Criteria means it has to be descriptive. See, criteria, we can call it, it's a matter of semantics.
Yes.
Other than means you have 4 socially and educationally backward.
Yes.
Now, other than can mean 2 things. The way we have understood so far is exclusionary.
Yes.
The other way to read, perhaps, is that this is descriptive. In addition to,
Yes.
The category in 4, we have this category.
What has been described in 4 and 5.
What is described? In addition to that, we have this. Therefore, in that event, there is no exclusion.
Yes.
Then you have you can call it a silo, you can call it a separate container, where everybody competes on the basis of poverty.
No, sir, as you can read it in any manner in a,
You are rendering the entire observation.
that is not a manner that is referring to human beings. Human beings. So, for example, criteria for sports persons is different from criteria for persons with disabilities. So, if you want to get horizontal reservations under either, you can be a scheduled caste woman who's a sports person and is disabled, and you have to deal with 4 sets of criteria. And there is nothing in interlocking reservation that says you cannot have multiple eligibility. So
what Justice Jeevan Reddy said, interlocking.
Interlocking reservations. So what I'm saying, sir, is that we read these as we ensure that there is no overlap. Now we can attribute, sir, rationality in saying that backward classes and weaker sections are very closely interrelated. They're 1-2 sides of the same coin. Therefore, all the more reason to ensure that the eligibility criteria are distinct and with intelligible differentia. So here, for example, no need to put this criteria on what your stigma is or your social status is. You can just concentrate on the deprivation. This MPI, so the multi-dimensional poverty index criteria. You can do that, and yeah. Sorry, sir, I keep. Sir, forgive me, sir. The last point I want to say, sir, is that yes, this may mean that the political intention of providing a separate compartment for a particular group may not be achieved, but that is not the concern, sir, of a court. And that will never be the concern of a court. First, this will not be the first time that a political intent has been frustrated by what Justice K.K. Matthew, I forget the judgment, beautifully once called the need for all constitutional provisions to be in fraternity with each other. So when this, whatever the political intent may have been, once 16.6 and 15.6 enters the house of the Constitution, it acquires all the characteristics of all its friends in the Constitution, sir. 21, 19, 14, 16. They're all one big friendly family, sir. And they have to live in harmony together. And so this interpretation, where we say that other than means that the criteria shall be distinct, eligibility criteria shall be distinct to avoid an overlap, will allow you, sir, to keep this going without running into the letting reservation run loose, disconnecting reservation from backwardness or poverty, and without
that process. They are disrupting the harmony. This entire process,
yes,
you in the alternative suggested way forward, it's required to be maybe is taken up only when if we come to a conclusion that these amendments, 103rd amendment, whatever is provided is not otherwise living in harmony with the other provisions of equality wherever they are. If they are otherwise, they could exist in harmony, they could exist.
Of course. But it all depends on what interpretation we give it, sir. These are not provisions which are neutral. So as I said, there are 2 interpretations you can give it. One interpretation will allow them to live in harmony, sir. But another interpretation will not. There's no doubt about it, sir.
Thank you.
Thank you so much, sir.
With my lord permission, I am seeking only 30 seconds.